The reason for denial is so dumb, but I think Drew Fillon ultimately won. Y'all gonna be like, what the hell?
What the hell?
Don't worry.
What the hell? What the hell?
United States District Court, Central District of California, Criminal Minutes General. Case number 224 CR 00621 MWF6. Date May 20th, 2025. Present the Honorable Patricia Donahue, United States Magistrate Judge, Interpreter, non-applicable. Let's go to right here. USA versus Defendant Banks. Durk Banks, present. Custody, attorneys for defendant, Christy O'Connell, Drew Fillon, Jonathan M. Brayman. I think I might want to do a deep dive on both of these individuals. We already know about Drew, but y'all let me know in the comments if y'all want me to do a deep dive on Christy and stuff, and then we'll drop all those on the Reloaded channel. Proceedings. Order denying application for reconsideration of detention order. On May 8, 2025, the court held a hearing on the application by defendant Durk Banks for reconsideration of the order of detention. The court considered the application, memorandum of law in support of the application, and the exhibit thereto. The opposition to the application, the second superseding indictment, SSI, which was filed on May 1st, 2025. The supplemental memorandum in opposition to the application the replay in support of the application and the exhibits thereto, docket numbers 136 through 138, 140 through 141, 147, 155 through 156, as well as the pretrial services. Reports dated October 25th, 2025, November 14th, 2024. So let me go back. October 25th, 2024, November 14th, 2024, December 12th, 2024, and May 8th, 2025, along with the arguments at the hearings on December 12, 2024 and May 8, 2025. On December 12, 2024, the court ordered detention on the grounds that no condition or combination of conditions will reasonably assure, 1, the safety of any other person in the community, and 2, the appearance of defendant as required. Docket number 116. By his application, defendant seeks release on 1, a bond secured particularly or in full by approximately $900,000 in equity and real property, $1 million in cash tendered by Alamo Records, and $150,000 in cash tendered by Nizia Ali Bahia. I don't know how to say that, so I said it to the best. Defendant's business associate, home detention with electronic monitoring. 3, around-the-clock security services, including around-the-clock surveillance by security services, reporting to pretrial services, and additional third-party sureties and guarantors to satisfy a bond amount the court determines to be reasonable under 18 U.S.C. 3142, docket numbers 136, 137 at 6. Defendant seeks reconsideration of the detention order pursuant to 18 U.S.C. 3142, which states in pertinent part, the detention hearing may be reopened before or after a determination by the judicial officer at any time before trial if the judicial officer finds that information exists that was not known to the movant at the time of the hearing and that has a material bearing on the issue whether there are conditions of release that will reasonably assure the appearance of such person as required and the safety of any other person in the community. 18 U.S.C. 3142F. Defendant argues the new information that has a material bearing on the dangerousness and the flight risk is as follows. 1, the SSI, I like to say SS1, does not contain the allegations in paragraph 6 of the introductory allegations in the FSI that defendant sought to commercialize SR's death by rapping about his revenge on TB. And 2, SSI does not contain the allegations in paragraph 9 of the means by which the object of conspiracy alleged in count 1 was to be accomplished in the FS1 that at defendant's direction, a co-defendant would pay the bounty or cost payment to be made for the killing of SR to the co-conspirators hired to kill TB. See docket number 227 FSI at 36. Defendant argues the absence of these allegations from SSI shows that the evidence against him is significantly weaker than it was at December 24th, 2024 detention hearing. And in light of the significant bond package and stringent release conditions that he proposes, there is now a combination of conditions that will reasonably assure the safety of any other person in the community and his appearance as required. United States District Court, Central District of California. Criminal Minutes General. Paragraph 6 of the FSI introductory allegation states that following the attempted murder of TB and the murder of SR, defendant sought to commercialize SR's death by rapping about his revenge on TB with music explicitly referencing audio from a news clip taken shortly after SR's murder where TB screamed, "No, no." After seeing SR's dead body, FSI docket number 27P3, the FSI quotes the song's lyrics ID at December 2024 detention hearing. Defendant proffered the declaration of a music producer that the song was recorded approximately 8 months before the murder and attempted murder alleged in the FSI. See docket number 138-1 at 27 through 28. The government countered that regardless of when the song was recorded, a video of defendant's rival screaming "no, no" was placed over the lyrics. But, bruh, he has no power over what other people do. See, that's why they had to get rid of the lyrics in this, because that's pretty stupid. Anyways, defendant states that after the December 2024 hearing, the government produced videos containing audio and video from news coverage of the shooting of TB and SR, in which TB can be heard screaming, superimposed over defendant's lyrics. Defendant emphasizes that he did not create those videos, and the government has failed to show any nexus between defendant and those videos. Defendant explains that the internet users who posted the videos have no affiliation with defendant or only the family, and it is misleading to suggest that he is responsible for these videos or that they evidence his commercialization of the murder alleged in this case. However, the December 2024 detention order does not rely upon the allegations in paragraph 6 of the FSI, as they have minimal relevance to dangerousness and flight risk. In any event, accepting defendant's argument that no evidence connects him to the videos does not change the analysis regarding dangerousness. Paragraph 9 of the means of conspiracy in Court 1 of the FSI alleges that defendant directed others to pay for a bounty for killing SR to the co-conspirators hired to kill TB at the December 2024 detention hearing. The court stated that although the allegations in FSI are not that defendant personally pulled the trigger, the allegations are that the defendant exercised a significant amount of control over other individuals, and that those individuals were acting at his direction. Docket number 138-1 at 44 through 45. Defendant argues that because the SSI does not contain paragraph 9, the information proffered by the government no longer supports the above referenced statement by the court. Defendant correctly states that the court's December 2024 finding regarding dangerousness relied on part of the allegation in paragraph of the FSI. However, the SSI contains allegations that defendant formed only the family, which acted as an association. In fact, individuals who engaged in violence, including murder and assault at the direction of defendant, and to maintain their status in OTF, that defendant was the leader of OTF. The defendant made clear he would pay a bounty to anyone who took part in killing TB for TB's role in killing a high-ranking OTF member and close associate and friend of defendant. And that as part of the bounty, defendant and co-defendant Wilson would pay anyone who took part in killing a TB and/or reward individuals with lucrative music opportunities with OTF, that defendant and Wilson will recruit others to find, track, and kill TB, that at defendant's direction, co-defendant Grant would procure cars, ski masks, and firearms to be used to find, track, and kill TB, that at defendant's direction, his co-defendants in this case traveled from Chicago to Los Angeles for the purpose of murdering TB after defendant had directed them not to book their flights under names associated with him. That defendant and co-defendant Grant flew on a private jet from Miami to Los Angeles so they could help coordinate TB's murder. That at defendant's direction, his co-defendants track stalked and attempted to kill TB. See, where that messes up, though, is why didn't Durk see them while he was in LA then? That doesn't make sense. That kind of kills what the hell they just said. See, generally, docket number 147 SSI, the allegations in SSI, along with the allegations discussed at December 2024 hearing, that in a separate matter in Chicago, defendant is alleged to have engaged in conduct similar to that engaged here. See, docket number 116, continue to support the conclusion that defendant uses his money, influence, and power to endanger individuals whom he perceives as a threat. The absence from the SSI of the FSI's paragraph 6 and 9 allegations does not change that conclusion. Defendant also submitted a letter from RSEC Group Security Services in support. The application docket number 156-1 as discussed above. The new information upon which defendant relies under 3142F are the differences between the FSI and the SSI. At the May 8th hearing, defendant acknowledged that the bond package is similar to that offered in December. However, the RSEC group letter states that it is written in response to court's concerns regarding potential risks associated with allowing a high-profile individual to have freedom of movement while under bond. It describes recommended procedures RSEC would implement, including a protocol responding to attempts to violate release terms. That protocol includes documenting the incident. The letter is undersigned and does not contain the last name of its author. United States Central District of California Criminal Minutes General, thoroughly notify law enforcement if necessary and immediately informing the court of any violations observed. The court is not persuaded that supervision by a third-party security company paid by a defendant addressed either the dangerousness or the flight risk. Indeed, the government advised pretrial services that defendant has repeatedly used at least 13 other inmate phone accounts to make phone calls from MDC to continue to violate BOP's prohibition of engaging in three-way calls. Defendant also has the means and influence to circumvent private security and not appear in court as required. As set forth the initial detention order, defendant attempted to leave the United States upon learning of the arrest of his co-conspirators in the case. According for all these reasons and stated at the hearing, the application is denied. So ordered. Damn. So there were channels reacting to what I said in my theory, and I think my theory is solid, like loyalty and betrayal, right? So this is one of the things, and I'm going to be fair, square, obvious, and honest. It makes more sense that Drew would piss off the feds. Because remember 4 months ago, right? The feds gave up 230 gigabytes added with 20,000 pages. That's what got the date already pushed back. We would have already had this trial already. Durk would be home right now, in my opinion. So you have that going. And I ain't gonna hold you. It makes sense. Because if you're trying to bury me in paperwork, if you're trying to bury me, one of those pages is the actual page that I'm looking for to mess around and basically figure out your strategy, how you're going to do it, and how to derail you, how to derail everything. I don't actually believe that these morons, I don't even want to call the feds morons. I'm just in my feelings from how they treated me in Chicago. I don't actually believe that the feds have proof that anybody was going to, quote unquote, try to kill a witness family member. I don't believe that. I believe they were told that. And that's why people probably didn't want to basically come and testify. They probably told the feds this. I'm damn near willing to bet on this one. I bet they told the feds this. Man, I'm not coming to testify on Durk. He'll kill my family. That's what seems more likely, because once again, and for the people who don't understand this stuff, bro, there is no way that Seti Nash, who ain't never stepped foot in a freaking capacity of a lawyer, never took any classes, can come up with these theories. And y'all think that the feds, who get paid billions of dollars to prosecute these cases, you guys really believe I'm that much more intelligent than they are? If you believe that, bro, I ain't gonna hold you. You got a lot of faith in me. I'm gonna be fair. You got a whole lot of freaking faith in me. I believe that the feds are basically saying that because why the hell would you not charge them with that? Wouldn't that make your case more? Y'all held on to them BS lyrics for as long as you could. They did. We seen it. They held on to the lyrics as much as they could till they realized, yeah, bro, you might want to let this go. The fact that the feds went to YouTube, went to Instagram, searched this up, specifically searched for that and thought, we going to put this in there. When y'all see things like that, you don't think that that's not common practice of how they're handling this case? For them to cite the DJ Academics interview, right? And essentially Durk said, man, and he should have said I had nothing to do with it. He said I wasn't even there. That right there is enough. And then for y'all to say basically, oh yeah, Durk, y'all know Durk, he had got on a plane and he had basically went to California, knowing good and damn well Durk has a place in California. So my question is, if Durk was such a idiot like that. If Durk was willing to say in text message, don't book anything with my name on it. If he was that dumb and using coded language that y'all could have figured out, why wouldn't he just drop the money off? Why not? Why wouldn't he have met with the shooters or anything? Why not? Why the hell not? To me, I'm just being fair. Some of y'all gonna be like, well, you know, City Nash, he probably thought he was smarter than what he was. And if that's your answer to that, I can't argue that. I can't. I won't even argue with you. I'll just give you that one right there. If that's your argument. But my whole thing is this. Everybody who believes Durk is going down, I get it. Y'all see the big badge feds. Y'all see the Diddy case. Y'all have heard boogie tales and stories of all of this stuff and everything like that. And I understand. But I had to ask y'all this question. When the hell have you seen the feds drop charges and had to create a whole nother indictment just to make sure a person doesn't get bond? Think about that. Just if you don't want to give me anything else, if you don't want to agree with anything else I'm saying, at least entertain that conversation. Just entertain that one if you can. Think about that. The feds were not letting go of the lyrics. They weren't. Drew had all type of proof, and these morons decided they were still going to hold on to it. To the point where they understood, because of Drew's writing style and how they argued it, damn, he gonna make this a big part. He's gonna basically make this a huge part of this. And once Drew is able to prove the fight, once the fight is done, once he's able to prove the pattern of behavior with the freaking flights, bro, I ain't gonna hold you. That right there is going to bode bad for them. So they're trying to evade and trying to leave and all of that stuff and everything. I don't get why Drew didn't just basically pound that to the pavement a lot more. I think he's going to hold on to that because I believe that's one of his strategies. In my head, it's just one of those, bro, do you really care about getting him out of the feds right now to go home? I just don't know. But as far as him being on three-way calls and all this crap and everything and using other inmates' phones, really? That's y'all ready to die over? All right, cool. And I don't mean you guys are actually going to die over. I mean, because I know the feds is watching. I mean that you guys were willing to stake your reputation and the ability to keep your fight alive. That's the thing you are going to hold out hope on. Are you kidding me? So, yeah, nah, bro. I'm not seeing it. I'm telling y'all right now, for those who are going to say Lil Durk is done and finished and stuff like that, I believe. I don't have any insight. I don't want to interview with Drew Fielding. I could have already had one. Dummy. I know 3 of his clients for the moron who made that video that made 0 sense. That's why you won't get a response from me, Princess Buttercup. One of the things is this, and I'm just going to be fair. What happens if the evidence is so underwhelming that it seems like the feds just decided to say, let's see if we can make this happen? Do y'all know if that's what's going to happen? Do you know the floodgates of people just deciding to, we just going to fight it out and see what happens? I don't know. Now, people are, I did see Lord Tibetrell say that, basically that the state could pick it up. I don't see that happening. I don't see dual sovereignty happening, because if we're knocking out everything that they're putting out and it's basically emphatically false, why would the state want to waste time on that? Just being fair. Like, if we can prove this, and this didn't even happen, I don't even see how the state of California would even waste their time on that. They too busy wasting money locking up people just to get ready for the Olympics. But hey, subscribe, turn that bell, stay notified, share to keep your people aware. Speaking of Drew Fielding, man, Rod Wave went from this to this. We'll be dropping that video in a couple of hours, but y'all can keep up right there with everything that just happened, like the Diddy case. Diddy is basically done, man. But hey, I'll catch you on the next one in a couple hours.